Hi guys, it's Kathy. I hope you're doing well. You know Miko trolls you, right? You know he doesn't ever forget to hit the like button. He's in every stream known to man. He's the mod. He doesn't forget. So the case, okay, so this first case today, I have to tell you, before you start hearing her speak, she has already told the judge about at least 12 other cars this guy has stolen. Okay. So you're going to see like 3 seconds of another case. And that is when my cat paused the recording. I didn't know. Then I realized and unpaused it, but not until I missed her talking about these 12 other cars that this man has stolen. He doesn't steal them for a reason. He doesn't like sell them or he doesn't need them. He just drives them for a little bit and then dumps them, and he ruins them to steal them. Like he rips everything out and shoves a screwdriver in there. But no, shenanigans are coming later. Don't worry. Do not worry. So here's the video that the cat paused. I was so happy when I was listening to this car case because it just kept getting worse and worse. And I looked over and I almost started crying. I didn't really but I was so upset. But I still got enough.
Where Mr. Alhambra was speaking with Mr. Anaya.
Vehicle to Denver to commit more crimes. And he ditched that vehicle in Denver and stole Mr. Thomas Bristol's Skyline from a parking garage from an apartment complex in Denver. He ended up bringing that back to El Paso County, where he ended up ditching that vehicle. And then on January 3rd of 2025, he's seen on surveillance video with a gun. And then on January 7th of 2025, he discharged a firearm into the apartment above him, where the victim was sleeping on his sofa, and the bullet entered into the apartment complex where that victim was sleeping. So this right here is Mr. Tatum's Forerunner. So this is the defendant entering to steal that Forerunner after he ditched the other vehicle that he stole. This is the UCCS parking garage, and this is how the Forerunner looked when it was stolen. This is how it looked upon recovery. It was spray painted, graffitied. The inside was completely trashed.
Remember you said that. Remember you talked about his taste in cars.
The ignition was obviously completely trashed. His vehicle was completely totaled. This is Chandler Van Rievsven's motorcycle. Again, with the drilled out ignition, this is his method of stealing vehicles. All of his vehicles have similar operations, and they are completely destroyed with their ignition. This is Brady Cook's Dodge pickup. I'm sorry, that went out of order. So this is Brady Cook's Dodge pickup truck. Again, the ignition completely destroyed. This is Lorenzo Gonzalez's Acura that was recovered. This is the one that was stolen 2 times. This is Mr. Connor Kennedy's motorcycle, and again, some of the damage to it. This is Juan Flores's motorcycle, again, with severe damage to it. This is Curtis Nash's Ford F-250, where the defendant likes to spray paint some of the vehicles that he steals, and he likes to put this tag on it. And so that's the tag that he left behind. And it's very similar to a tag that he left with some of his misdemeanor cases, where he is tagging police vehicles with a similar tag. This is Matthew Harold Shirley's Subaru upon recovery. This is how he had to drive it in order to get it started because he couldn't start it with his key any longer. This is Brianna Schaad's Subaru. So this is the parking garage in Denver where he used this vehicle to break entry into this garage in order to steal a Skyline there. And so this is him. There's video. So he drives the car into the garage, breaking the garage door. And he's prepared. He's planned to do this. He's got his tools necessary in order to steal another vehicle. So he'll get out of this vehicle equipped with his tools. This is a couple minutes later. He needs to be able to get the Skyline out of this garage. So he uses the other vehicle, plow through this garage door again. And then he's going to get out and he's going to manipulate the garage door by hand. You can see him walking up now, trying to move the garage door again out of the way.
I was just
He
singing.
runs back to get the Skyline.
I was just singing. So I'm very, 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 very glad I'm muted.
We're just within a couple of seconds. He's taking his new stolen Skyline out of this garage, where he ends up taking it back to El Paso County, where he ditches it here. This was a motorcycle that he was found with. He was found manipulating on his property the day he was contacted by law enforcement. And this is the Skyline upon recovery, abandoned on the road, damp.
There was a car he was trying to, he was stealing when they saw him stealing their car. So the guy came out and tried to fight him, and he drove away in his car. He did successfully steal that car.
Ignition damage. Obviously, this is an expensive vehicle. Somebody took pride in this vehicle, and he completely destroyed that. Now, these next clips do have some audio, so hopefully that'll work.
It works. Don't worry. This is where what Micah came in. When Micah said he has taste in cars. Well, he's going to talk about that right now.
Turn it up on your side.
Rebecca, I love you. Hello, Beck. I'm sorry. I was excited. Beck, hello.
And they're all fairly short clips.
I want to bring to your attention a couple things. Like I said, you and Josh were on ankle monitors. What I can tell you is DOC provided me with all of your guys'
No, he was with Josh.
information. We used those and correlated them to motor vehicle thefts throughout the city. Okay. And we're able to put you and Josh at multiple motor vehicle thefts. Okay. So my question for you is, were you and Josh out there? What were you guys doing taking these bikes? Were you, or even the trucks or anything like Subarus, Acuras? There's quite a few different makes that I can tell you that you guys were out for these steals. So my question for you is, what are you guys? I'm assuming you all are taking them to make money, or are you just joyriding with them? Like, what is the point of the thefts? Do you know what I'm saying? Because they're always recovered eventually, for the most part, except for a couple.
Really don't even know. I don't know.
Okay.
Just
So another thing I can tell you is there was a red Subaru that was stolen from an apartment complex off Bijou. And then the red light camera got you driving that. Do you remember that?
so
Yeah.
the only reason I saw that was because there was a Skyline thing on 719, whatever you can't drive or whatever.
Oh, yeah. Mhm.
And all these people are saying that, like, trying to associate me with that shit.
Yeah.
But like, dude, I got rid of that. Tim took that fucking car.
The red one?
The Subaru.
Okay.
He sold it, didn't see it again. Haven't seen it since.
Okay.
I don't understand, like, this is like
How they
a
put you-
part. You know what I mean? Like, all these, I don't get it.
Yeah.
Yeah, it wasn't me.
So what happened? So how did you end up being caught in like the driver's seat in the red light camera?
I was driving it.
Well, did you get it from Tim or did you take it from the apartment complex?
See, I got that car from Tim, but I don't know how he got it.
His GPS monitor places him at the scene of this vehicle being stolen. And this is the one that was used to get into the garage in Denver. But instead of taking any sort of accountability, he's trying to shift the blame to somebody else.
Saying I'm curious about where it went. It's an Acura, the 1990 silver Acura. And it's still missing because the only thing I was missing was that bike, but we found it today at the Huntsman address. Okay. The other one is that Acura and I can't seem to find it. I'm curious as to if you would know where it would have went.
I don't even know, because like that's the thing is I wouldn't take that car.
Okay.
You know what I mean? Like, I just wouldn't take that kind of car.
What I can say, like I said, is I do have your guys' GPS monitors, right? And so like when that red car was stolen, you were in that parking lot at the time it was stolen.
Okay.
Okay.
I mean, yeah, I don't really know what else is like.
I mean, is that right? Like, were you,
I was there.
okay?
And so trying to push the blame onto someone else.
It looks like there's quite a few.
Just listed here. 11.
Yeah, so I'm buzzed.
Like I said, I want to give you your opportunity to talk about it. You know what I'm
Yeah, I
saying?
can't though. I'm buzzed. It's all good. I'm sure.
Something about looking for money. But my question about the money part is like, y'all weren't keeping the cars. So I didn't understand where the getting money part came from.
Well, it's never everybody paid them, but it's not the same anymore. The G-Rides ain't the same. You don't make money off G-Rides anymore.
See, that's what I thought. I'm like, I mean, we have some suspected like chop shops, right? In the
Right.
city that we're suspected of. But I mean, yeah, I guess I don't understand if, I'm sure there's something in Denver people can drop cars off or.
See, even if there is, I really wouldn't know because, like I said, like I wasn't trying to do that shit when I got out, man. Like,
Cause it's interesting, cause it's like some of them, like y'all literally drove around the corner and then ditched it.
yeah.
So like, I just have like, what's the point in that? I just want to understand like y'all's mindset a little bit better on like why, like the Texas Roadhouse truck. Like that was literally, there was a truck right next to the Texas Roadhouse that got stolen. And y'all drove it over to like Oro Blanco and something and then ditched it. And so it's just like, I'm just curious as to like, or even there was like an Acura that happened twice. The Acura was stolen twice from the same neighborhood and then dumped around the corner. So I'm just curious as to why you guys would do that.
Stupid.
Is it like
It's almost like I don't even know. It's almost like I do the things I do just in the background of where I'm at now.
is it like an adrenaline thing? Or is it boredom or
You know, honestly.
it's like the only thing you know? How long have you been stealing cars from? Like how old were you when you first started?
16.
16.
So you're on a note from the PSIR, they utilize tools that says he poses a high risk to reoffend criminally.
Yeah, but he said he wouldn't steal those cars. They're not his taste. He couldn't have done it because he would never steal that kind of car. My sister started at 14 stealing cars. So he's a late bloomer.
He has 10 prior felony convictions since 2016. And I would note those are just convictions. He's had many cases that were dismissed as part of global plea offers. He has many cases that were pled down to misdemeanors. So the amount of felonies he's committed in the last decade has been much higher than is reflected in that number of 10 prior felony convictions. He has 5 prior motor vehicle theft related convictions. Again, some misdemeanors, some felonies. He does have some violent criminal history as well, not just all property related crimes. So when looking at the sentencing factors under 18-1-102.5, first, to punish a convicted offender by assuring the imposition of a sentence he deserves in relation to the seriousness of his offenses. I would note here that this was a massive crime spree. He committed multiple class 3 felonies. This is what the legislator intended when they enacted the class 3 felony habitual motor vehicle theft offender. How quickly he did this after getting out on parole, about a month after he is engaging in lots of different criminal activity. I think this factor supports a lengthy DOC sentence.
Yes, they still get me. They still come after me because of my sister.
Under subsection B, to assure the fair and consistent treatment of all convicted offenders. I would note his co-defendant got 18 years and he had many less charges pending than this defendant does. In my view of the evidence, it seems like Mr. Hall is the ringleader of the operation of stealing cars, and he brought Mr. Green along with him on some of those, but the majority of them he did by himself. And that's supported like on the surveillance video that Your Honor saw from Denver, where he went there by himself. He was the only one entering and exiting both of those stolen vehicles, and he would often ditch one in order to get into the other one. I would also note that on jail calls, Mr. Green was arrested first, and he was being held on a parole warrant. He and Mr. Hall continued to communicate over those jail calls where they plotted to try to move some of the property that they had that was storing some of the stolen property. So there was a motorcycle and a trailer that they were trying to move, and they're trying to coordinate hiding it from law enforcement. Under subsection C, one of the sentencing factors is to prevent crime and promote respect for the law by providing an effective deterrent to others likely to commit similar offenses. I think that this is important in this case to promote respect for the law here. As you can see from his 10 prior felony convictions, those have not changed him. He doesn't have respect for the law. He's continued to engage in this type of activity for a long time. He's given opportunities for treatment, for community corrections. He's never complied. Being on parole didn't stop him, didn't give him respect for the law. And most importantly, the highest thing that anyone could ever do to supervise someone, a GPS monitor, knowing that somebody can see your every move, didn't stop him from doing these crimes, didn't stop him from victimizing people within our community. Under subsection E, to select a sentence length and a level of supervision that addresses the offender's individual characteristics and reduces the potential that the offender will engage in criminal conduct after completing his or her sentence. And again, nothing has stopped him so far. At some point, we do have to protect the community from crimes. And I think we're at that point right now. He's demonstrated that he cannot comply with the law. And I think a long sentence is the only thing that's appropriate here. And again, to promote acceptance of responsibility and accountability by offenders and to provide restoration and healing for victims and the community while attempting to reduce recidivism and cost to society.
One of his old crimes that he was already sentenced to, pled guilty to or whatever, was spray painting police cars. Hi, Best.
by the use of restorative justice practices. Again, he victimized so many people within our community, so many people who couldn't get to work, so many people
Security,
who
thank
couldn't
you.
provide for their family,
I appreciate
couldn't get
it.
to the grocery store. And you heard that it does shake their sense of
Thank you, JK. Thank you, security. Thank you, thank you, thank you.
security. And not only do we have motor vehicle theft related crimes, but we have offenses with firearms. And that's something I think the court should consider as well, because somebody could have been shot when he discharged that firearm. Luckily, no one was. But I think it's also important to consider when he's committing crimes like this and people's livelihoods are on the line, that's when people want to defend their property. And if he has firearms and he's possessing them illegally, and if he has them on him when he's doing crimes, that can lead to much harsher and worse crimes that could have come from his actions. And so I do think that that is something the court should take into consideration. I also think the court should consider that he also, even when caught red-handed, when his GPS monitors put him at all these locations, many of them had surveillance videos of him, he's still trying to shift the blame to other people. So I think even at that point in time, he wasn't accepting responsibility or accountability. And so I do think a longer sentence would account for that factor as well. So based upon all of those reasons, the people are asking for a sentence in the upper range. I do think something in excess of what the co-defendant got of 18 years is appropriate, because the co-defendant was involved in far less of these crimes, and he did most of them.
Stealing a bunch of cars. And he had an accomplice, but his accomplice really didn't do that much of it. It was all this guy.
On his own. And only a couple of them were they doing them together. So for those reasons, I think a range in the higher range would be appropriate. I would also note that we have been in communication with all the victims. We have documentation regarding the amount that they've paid. Most of their vehicles have been totaled, as you can see from the photos. And so we are working to cross-reference it with the insurance companies to make sure that every person in business are accounted for, and to make sure nobody's double dipping in that. So we are asking for the 62 days under the new statute in order to provide those documentation to the court and provide the final number. However, so far, the amount that we have been able to confirm is $7,862.95. However, I note that that is just a fraction of it, because again, we're doing that cross-referencing in order to make sure that all victims are accounted for.
Thank you, Ms. Bullock. Mr. Hall.
Son of a bitch, my car's gone. My car's gone, guys. Help, help.
If you wish to say anything, you do have a chance now. If you don't want to say anything, I'm not going to hold your silence against you. But if you do want to say anything, now's the time.
Oh, yeah, I actually have something that I would like to read. If that's all right.
That's fine.
What's that?
Okay. I wrote this letter initially. I was going to send it to you, but my attorney advised me to just read it in with you right now. So it says, Your Honorable Judge, I'm writing you this letter in hopes that I can help you better understand who I am as a person instead of the charges that I'm pleading guilty to. My name is Tyler Connor Hall. I'm 28 years old, and I was born in Denver, Colorado. Since as long as I can remember, my mother has had a better relationship with the bottom of a bottle of vodka than she has ever had with me and my little brother, Bobby. In short, I've been around my mom for no longer than a couple of hours throughout the course of my life. My father, on the other hand, did what he could as best he could while trying to deal with an active cocaine addiction. As I got older, that turned to an even worse meth addiction. Eventually, he lost grip, and we were taken by the state and sent to live with other family at first, like aunts and cousins. And then when that didn't work, it was random people who never really seemed like they wanted us there. Throughout the years, one thing really always remained consistent, and that's the trash bag that held all of our belongings when inevitably they would call our caseworker and tell them whatever reason that they had that we couldn't stay there anymore. Eventually, I stopped caring about trying to make friends or getting used to being somewhere because it never lasted long. So I started having the mindset of why care or why try. When I started high school, my father had gotten his act together long enough to get me and my brother back. One morning while leaving for school, I noticed my dad asleep on the couch with a meth pipe resting on his chest. He rolled over and it fell to the floor. I picked it up and left for school. I've seen my father do drugs like I was never even in the room, so I knew exactly how to do it. And from that day forward, I battled with my own meth addiction. I'm sure you guys all very well know that with drug addiction, people do whatever it takes to get them. And I wish I could say that I'm different and I'm stronger than that, and that I wouldn't allow the drugs to control me, but sadly they did. I'm not by any means oblivious to my drug problem, and yes, it is very much a problem. I grew up never learning how to deal with my emotions and feelings in a healthy way, so when I feel something that I don't like, I turn to drugs because that's how I cope.
Nope. Sorry, but nope. He didn't steal these cars to sell them or strip them for parts or whatever to buy drugs. So nope, that's not what he did. He just stole the cars because he steals cars. That's what he does.
That's not to say that I don't know right from wrong. I'm very aware of the difference in the two. I'm also very aware that I've done wrong, maybe more than I've done right. I'm not shying away from that. And as I read this letter, I feel truly ashamed of the things that I have done because I know that my actions have caused hardship. I'm embarrassed and disappointed in myself for letting my addiction drag down my self-esteem and my self-worth to the point of allowing myself to come back here yet again, as well as hurt people yet again. I have reached a crossroads in my life, and I have had enough of letting my family down and leaving my loved ones for years at a time, as well as hurting people. I've recently found out that I'm going to be a father, something that I've always really wanted to be. Of course, I'm extremely angry with myself for the fact that I will be gone for the beginning stages of my child's life, but now I feel like I actually have a purpose. I have been a bad son, a bad brother, bad friend, but I will not be a bad father. Whatever sentence that you hand down to me, I'm sure will be just. I will take the time that I'm given, and I will use it to better my education, get a handle on my drug addiction, and strengthen my relationship with God, as well as do anything that I can to make sure that when I am released, either on parole or in community corrections, I'm a completely different man, so I'm better equipped to take care of my new family and give back to my community instead of take from it. Thank you.
Thank you, Mr. Hall. Ms. Bolig recited the purposes of the code with respect to sentencing. I'm going to touch on those as well. Before I do that, I do need to acknowledge, I think, that Mr. Hall, you had a very tragic upbringing. No one disputes that. And no one disputes the fact that being dealt that hand did you no favors. The flip side of that coin right now, though, is that when you engage in behaviors that you engage in, you hurt other people and you cause other people problems in their lives. And it's one of the biggest issues that we see, that people who have grown up in the way that you've had to grow up tend to sometimes push that badness out into the community. And that's where you are right now. Fundamentally, sir, you were going to be going to prison for a significant period, whatever sentence I pick. And fundamentally, everyone here recognizes, I think, what a waste that is. Mr. Hall, you are one of the more creative people who steals cars that I've ever seen, in terms of the different ways that you bypass ignitions, the different ways that you get into things. I really wish you would use that for good, because The fact that you've learned how to do those things, the fact that you're able to do those things tells me that you could have skills in a lot of really positive ways. Instead, they've been negative. And that's a waste. It's a waste of talents that you have. It's a waste of your time. It's a waste of our money when you're in prison. But fundamentally, sir, you have the ability to do better. And I hope you can find a way to do that. Ms. Bolig went through it, but one of the primary concerns is to punish people by imposing a sentence they deserve in relation to the seriousness of their offense. You pled guilty to 5 different Class 3 felonies here when you were on parole or when you were just released from parole. That's a big deal. Court has to assure the fair and consistent treatment of all convicted offenders by eliminating unjustified disparities in sentences. Court has to consider the prevention of crime and promoting respect for the law by providing an effective deterrent. And Mr. Hall, you did a lot of bad things. That merits a significant sentence here. The court has to promote rehabilitation by encouraging correctional programs that elicit voluntary cooperation. And to be very candid, that's the only thing that can potentially work now for you, that voluntary aspect. Everything that we've tried thus far hasn't worked. You are going to have to find something that gets you there, whether that's your child, whether that's being tired of wearing orange, whether that's being tired of throwing your life away. Something's got to flip that switch for you. I don't know what it can be, and I can't tell you what it is, because it's something you got to find. But rest assured, you can find it. Court has to select a sentence length, and a level of supervision that addresses individual characteristics. And right now, Mr. Hall, the DOC is the only place that makes sense. It's because the concern is that you're going to sort of fall off the wagon and engage in the behaviors you're engaged here.
He's also really good with drills.
Mr. Hall, you're going to be walking out of here with a significant sentence, like I said, one way or the other. No matter the sentence I impose, though, I believe you're what, 29?
Yes.
You're going to be getting out of prison on that sentence. What your life looks like at that point will bear a direct correlation between the work you do from now until that day.
This is what I was talking about a bit ago in one of my streams. And it was from Colorado as well. Like, Grand Theft Auto was a big freaking deal when I was growing up. And, you know, it started back in the wild, wild west. If you stole someone's horse, you got hung. So it was a big deal. It was a bad thing to steal someone's car. You know, you could steal their stuff, but if you steal their car, then you get in big trouble. Now stealing their car is just the same as stealing their other property almost. It's not like so bad like it was back when I was growing up.
You get out.
Yes.
And you have to focus every bit of energy that you have on that day. If you can take programs in DOC, take them. I don't care if you're not interested in them initially. I also don't care if they're not something that you think may help you in the long run, because you never know what's going to help you in the long run. You have to find those things, and you have to find something that drives you and that doesn't put you back in orange when you get out this time. Because that's ultimately the goal here. I've thought about this case a lot. The sheer volume of the crimes that you pled guilty to, the harm that you've done society, all of that requires a significant sentence. But like I say, every single bit of your life needs to focus on that day you get out. Mr. Hall, I never feel good about taking someone away from their children. It's not the goal here. And fundamentally, children are always the people who suffer the most when their parents commit crimes. I say that not to make you feel bad, but to recognize the fact that whether it's a 12-year sentence or a 22-year sentence, you're going to miss part of their lives.
Yep.
And that's one of the biggest costs. After considering all these purposes of sentencing, after considering the statements that have been made here, after considering Mr. Hall's age, his prior convictions, considering the sheer volume of victims here, the way that their lives were affected, the court is going to impose a sentence of 20 years, Department of Corrections. That will be on count 1, count 2, count 7, count 8, and count 9. Those sentences will run concurrently. They will be followed by a 3-year period of mandatory parole in each of those sentences. Against those sentences, you have 145 days credit time served. In terms of restitution, the court does find that the prosecution has exercised diligence in trying to determine the amounts. The court notes that restitution is owed. That preliminary figure is $7,862.95. However, the court will afford the people 62 days to determine the final amount. Once they submit that, it's fine. You'll have 14 days to object to it. If there is an objection, the court will then set the matter for hearing. Mr. Hall, you may spend less time incarcerated than that sentence. And in some ways, I hope you do, because it'll show me that you're doing things right. But your actual time spent in custody will depend on a number of factors, including credit for good time, earned time, correctional education programming, community corrections eligibility, prior criminal history, and other factors. Mr. Hall, if you can get your college degree while you're in there, get it done. I don't know whether that program will be available to you, but if it is, do it. Because the only thing that can do is help you when you get out. With that, anything else from the people?
No, Your Honor.
It's fine.
Yeah, thank you.
Mr. Hall, good luck, sir.
Thank you, Your Honor.
Deputy, I'm sorry we kept you past 5.
So he won't do 20 years. But if you noticed, he gave him 20 years on each and every count of, not each and every count, but all those different counts. That way, if the guy comes back and, like, let's say the Honda theft was really done by Josh, and the guy comes back and says, that wasn't me, and he proved it was Josh, blah, 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 blah. He still has 20 years in all the other cases. So no matter what happens, he's going to be in there for a while. I think we should move on to Shenanigans now. The lawyers are the stars of this show, not the inmate or even the judge.
Is in.
Ouch.
I don't see Attorney Gagnon.
Attorney Gagnon has withdrawn. If that has not been processed, I will make sure that it's taken care of. He's no longer with my firm.
Attorney McFadden, if you kindly identify yourself for the record, please.
You're muted, Leslie. There you go.
I'm sorry about that. Leslie Gold McPadden for the plaintiff. I'm the person appointing Tracy Cohen for Pro Hoc Vice. I'm with the Bernstein Law Firm in Middletown, Connecticut.
All right, so that was the question. Attorney McFadden, you filed an appearance individually and then also for the Bernstein Law Firm just recently? You're on mute.
I'm so sorry. I switched law firms last week.
Okay.
So I've just been at this firm for a couple days.
So before we take up the motion for Pro Hoc Vice, there are a number of matters, and just reading the complaint and that have been what I refer to as a similar nature that were referred to Complex and Waterbury. There's no relation to those cases, or are there relation to those cases?
There are not, Your Honor. We may end up seeking that this case be put into Complex, but we're not at that juncture.
So it's not a companion case with anything else?
No, it's not.
I have been admitted Pro Hoc Vice in those cases. In the one case that is filed by my firm in those cases, this is a completely different incident.
Okay. So the reason I scheduled the Pro Hoc Vice motion, have been scheduling more of them is, and the concern, Attorney Cohen, that I have is that you've resolved some of them, indicating that Attorney Gagnon is not going to be, is going to be withdrawing his appearance. Attorney McPadden, you clarified some issues as well, that you are one and the same with as the Bernstein Law Office, because obviously every attorney has to appear for every hearing, and we're doing more and more live events. So the question I have is, it's really only getting some early pre-trials and early status conferences are remote, but everything else is in person. Attorney Cowan, how is that going to be handled?
So for any hearing that I need to appear at, I will be appearing. If it's in person, then I will come to court and appear in person.
Is there any objection, Attorney Stockman?
You know, in all the years I've practiced, I've never objected to one of these. I will say that this is the first one where I've had some.
Another marathon. Oh man, last one was long. I do have off. I do have off over the 4th of July weekend. And I have, oh, I almost clicked it open. I have a trial. I have a trial. We'll see if anybody wants it. If anybody wants it, let me know. We want to do a marathon over the 4th of July.
Significant concerns.
Like
And
the
my
last
concerns
one.
are as follows. It's pretty clear that this litigation is being run out of California by people who are not admitted in Connecticut at this point. In fact, they've been filing things with Attorney McPadden's name misspelled and signing it with the misspelled name. And I know that I've known Leslie for a long time. I'm pretty sure she knows how to spell her own name, which means that the people in LA are signing her name onto pleadings. I also know that it's the people in LA because they're filing complaints and not certifying them to us.
You poor thing.
So twice in this case already, we've had complaints filed with deadlines to respond to those that have not been certified to us, which is a concern because that's a staple of Connecticut practice. So I think we're at the point where that's been resolved because now we've had another revised complaint filed on the 27th, which is, I think, the complaint I have to respond to going forward. But Your Honor, I'm concerned that we've got litigation literally being run from across the country, and I don't know how to get assurances that these shenanigans are going to stop, but I'd like them to stop.
Judge, stop the shenanigans, please. She said she just started this firm 5 days ago and he saw blood and he went after her. Just trashed her right in front of the judge. But wait till the end. Your dignity.
Your Honor, if I may, Ms. McPadden's office is the office that has handled filings since Attorney Gagnon has left my firm. So I certainly I want to correct that mischaracterization. I understand why Attorney Stockman would be concerned, and there have been some inconsistencies lately.
I know what I'll do, guys. I know what I'll do. I'll do a marathon. I'll do a marathon. But I'm going to find the sleepiest lawyers I can the sleepiest judges I can possibly find towards the end.
In terms of providing notice to his firm, I think that was a miscommunication between my office and Ms. McPadden's office, which has been in some, transition period. But I believe that has all been worked out.
And Your Honor, I am incredibly apologetic to counsel
Not 24 hours of pondering. I'm gonna throw in an hour of chair watching.
in the court. In the last week to 10 days, my computers still aren't hooked up correctly. It's been a very difficult transition, but we're 3/4 of the way there. And I have worked on as local counsel to lawyers in both Philadelphia and Chicago on cases all the way through verdict. And I've been a medical malpractice lawyer in Connecticut for over 30 years. And this is unusual for my part in the my role in the whole thing to be so sloppy, but a lot of it has been that I've just had a lot of trouble functioning until I get myself sort of settled here at the new place, and these things will not happen in the future.
All right, I would just note, just looking at the practice book, section 2-16, which provides that any and all pleadings a member of the bar of this state must be present at all proceedings, including depositions in the proceeding, and must sign all pleadings, briefs, and other papers filed with the court, and assume full responsibility for them and for the conduct of the cause or proceeding and of the attorney to whom such privilege is accorded. I think Attorney Stockman's concerns or objection are noted, and they'll be obviously they're part of the record. But I will grant the application with the understanding that Attorney Cowan has acknowledged that the majority of our proceedings are now in person, and specifically any.
So there's this case that's been around forever and ever and ever and ever, and it's getting really old. Okay. And he's objecting to this lawyer right here because she works for a firm in California now. And all the filings that are going into the court are coming from California, from this law office out there. And they're spelling his name wrong, which he knows she would never do. They're doing all this stuff. They're filing the wrong things at the wrong time. No, we're not doing the smiling lawyer. No way, I can't. I just can't. You don't even know what it did to me. So she just started 5 days ago. So, she's not on top of things because she had to move across country, blah, 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 blah. So, yeah, he's complaining about her. And he just threw her AI law firm. You know what? I wouldn't even doubt it. The way he spoke about some of the things that they filed, I wouldn't doubt it. But he threw her on the bus. She had to apologize to the judge. And now it's almost over.
Early motions, motions to strike, motions to dismiss, motions for summary judgment are all in person, as well as our pretrials and trial management conferences. So with that acknowledgement, I'll get the order out today. I certainly appreciate everyone's courtesies and cooperation with each other. It's very much appreciated. And Mr. Fagan, just because there's two people present in the courtroom, I'm going to just so they're aware that we will take a brief recess, Mr. Fagan, so that you can come up and be the monitor for the next hearing. But I would only indicate that certainly take your time, and we'll get going as soon as that you get up here. So with that, we'll take a brief recess with regards to the Coulter versus Leandris matter. And I hope everyone has a nice day. Court stands in
Thank
recess.
you. Thank you all. See you soon. Take care. Best of luck, Leslie.
Thank you.
And now he's acting like her best friend. Okay. I need to get something. Before we get to the next case. So this inmate is suing sugar. The oh, I don't have it. The state of Connecticut, I think, or he's appealing the decision. I have two cases that I want to show you. The first one is an inmate who is appealing his decision. He's in jail for a long time. Trying to get it, trying to get the complaint ready for you. I had it ready. No. All right. 10 o'clock. Give me the 10 o'clock ones. Please, please. I only have like 4 more seconds before I got to move on, dude. All right. I got to move on. Okay. But the thing is, the judge doesn't put the camera on. So we only have the screen. You'll see. It's kind of confusing, but an inmate is stuck in jail right now. And he is appealing the decision that kept him in jail. And he's already appealed a couple times. And he's already lost a couple times. So he's doing it all over again. Pro se, of course.
Charlie.
Oh, and I found out what this is. So when I press record, there's this bar right here that, you know, you press record and it disappears. And then right by that bar, there's this little pencil right here. So I can draw on the screen if I want to. Well, this has stopped it disappearing. So I found out today, and I can drag that off of the screen once I start recording. So we won't have this an irritating box after today, because I figured it out today. This is what we see the whole time. See, that's when the judge comes in.
The Superior Court for the Hartford Judicial District is now open and in session. The Honorable Judge Schumann presiding. Good morning, Your Honor.
Good morning. This is the matter of Devon Smith versus State of Connecticut. Mr. Smith, I see you. Can you see and hear me?
Yes.
All right. Good morning, sir. And for the respondent, your appearance.
Thank you, Judge. Good morning. Joanne
Morning.
Sulik for the respondent, State of Connecticut.
All right. Good morning. This is a hearing on the petitioner's motion for summary judgment and the respondent's motion for summary judgment, essentially cross motions for summary judgment. Mr. Smith, you filed your motion for summary judgment in August 2024. I've read all of the papers on all of the motions, so you don't need to go through them in great detail, but I'll hear anything additional you would like to say. Mr. Smith, I'll start with you since your motion was filed first. Ms. Sulik, yes?
Yes, Judge. One housekeeping matter before
Okay.
we begin. I have received from Mr. Smith a document titled Motion to Dismiss, dated May 28, 2025, in which he moves to dismiss the instant case on the advice of attorneys at the Connecticut Innocence Project. I see that has not been docketed.
Right.
I did receive this copy, so I'm a bit confused.
Right. I am not aware of that. So, Mr. Smith, would you address it?
All right, so I filed that motion, like Attorney Sulik said. The problem was the original that went to the court, I forgot to sign the face sheet of it. They returned it to me. I signed it and I sent it back. I don't know why it's not on the docket.
Right. It's definitely not on docket. This is the first I've heard of it. Well, let me ask you, do you want to dismiss the case?
That's correct.
You know, at this point, since I spent a fair amount of time preparing for it, and I'm sure Ms. Sulik did, and both sides have written a lot, I would consider any withdrawal of the case to be with prejudice. I know you've been through that issue before, but do you understand that?
I understand that, Your Honor.
All right, Ms. Sulik, do you want me to go ahead and perhaps canvass Mr. Smith a bit on the withdrawal, or do you have another idea of how we should approach this?
I think Mr. Smith has been through this before. I think a canvas would be appropriate. I don't think it needs to be in depth since I believe he's well aware of the issues.
All right. Thank you, Ms. Sulik. So, Mr. Smith, you're right. This has not been filed, but what I would consider to be the equivalent is an oral motion at this point to withdraw the case. And if you do, I will find it with prejudice. So is that what you want to do?
Yes, I'm time barred on this matter anyways.
Well, that was one of the issues, and you may well be right about that. So
does your calendar just go from July 3rd to July 5th? I would just skip the whole day because you don't get any hot dogs. You don't get any hot dogs with mustard on them.
am I correct that you are withdrawing this case with prejudice?
I'm withdrawing the case. If that's the court's position, then
Okay, so be it, right. So do you understand that if you do withdraw it, because this is basically beginning of the hearing on the merits, that I would consider the withdrawal to be with prejudice? Do you understand that?
I understand that, Your Honor, but I wouldn't want the court to do that. If the court chooses to do so, that's the court's prerogative. Okay. I did file a petition, the motion to dismiss within the appropriate time frames.
I see. Okay.
Like I said before, in the beginning of this situation, the facility's mail is a week.
So just so you know, this guy right here, it's murder, but it might be involuntary manslaughter. I don't know. He shot up some house and the bullet hit another house and killed someone. And oh no. Wrong guy. That was the wrong guy. He had drugs in a school zone and he was selling them. And he had 1/2 ounce of heroin and cocaine in the school zone. And he didn't actually have the drugs. Nobody saw him with the drugs, but the drugs were there and he was there. So he pled saying, yes, I had access to those drugs in this school zone. And he pled guilty for something else, but I don't remember what it is. Doesn't matter. So he's in jail for this. Well, the main witness that said that he did this, Rodriguez, recanted and said, no, I really didn't see him with this. So he's saying that the lawyers didn't fight hard enough for him or blah, blah, blah. So it was ineffective counsel, but he took a plea. So the judge said, did you in fact have 1/2 ounce of heroin and cocaine on this day in this area? Yes, I did. And did you intend on selling it? Yes, I did. All right, I'm going to find you guilty. And here's your sentence. And he got sentenced like 20 years. He was expecting 9 years. And he got like 20 years. So he's trying to say the police department forced Rodriguez into naming him or whatever, even though he pled guilty, and he's trying to get it overturned. And this isn't the first time he's trying to get it overturned. And because this isn't the first time he's trying to get it overturned, what this judge is saying is, because in this hearing that we are at today, the inmate wants to drop it. He wants to dismiss the case. And the judge is saying, that I will dismiss this case. However, it's going to be with prejudice. So you are not allowed to sue them again. You are not allowed to bring another hearing. You are not allowed to put in another appeal. You're not allowed to do it. This is with prejudice. And the inmate's like, wait a second. No, judge, come on.
A week late. They hold it for whatever reasons, I don't know.
Right.
But again,
Yeah. You have said that before, and we've experienced that before. I think you're correct in that regard. Let me just ask you this. Did anyone force you or threaten you or promise you anything to get you to file this motion to dismiss and request withdrawal?
so this will be the canvas.
Yes. I'm going to ask you a few questions.
Okay.
So, did anyone force you or threaten you or promise you anything to get you to file the motion to dismiss and withdraw the petition?
No.
Okay. Do you feel you're doing so voluntarily and as a matter of your own free will?
Yes.
And apparently you have spoken to an attorney about this matter?
Hey, Bill, how are ya? Listen, Bill, I don't know if you're streaming on the 4th of July. I don't know because that's days away. But I'm doing a marathon that day, all day long. I don't want me to step on your toes. And everybody can completely just leave my stream when you start streaming. It's fine. It's absolutely okay. But I wanted to run that by you real quick. That we've decided to do a marathon since I have off. And I have a long case, I think. I hope I have a long case anyway. And you can guest appear on the marathon. I can invite you in StreamYard. Just give me a time. I'll be here all day. I love Canada. I love Canadians. I love them, love them, love them, love them, love them. Me. Also a huge fan, Kelly. Huge. And I love maple syrup and pancakes and bacon and sausage.
That's correct.
And
No,
so,
Chinny.
do you feel
No.
you're making a
Listen, if there's one single favorite YouTuber of mine on all of YouTube, and that includes Captain Sparkles, it's Bill. Go always see Bill's stream when you can. You will not regret it.
an intelligent and knowing decision?
Yes.
Okay. And at this point, you do want to go ahead and have me act on the motion to dismiss and your request to withdraw.
Yes. With respect to filing a petition for a new trial.
Right.
I'm going to try something on the 4th of July too. So every morning I drive my daughter to work now. I hear the same ad on the radio, and it's about this grill. Okay. And they say somewhere in the ad that you can grill burgers and bake an apple pie. But it doesn't sound like he's saying bake an apple pie. I don't know, Carlos. We'll see how much money flows. Seriously, I'm going to stay on. It's not going to be like $1 a minute. But if people want me to stay on, then they want me to stay on. If they don't, then they don't. So, but it sounds like he's saying bacon apple pie. Bacon apple pie. So I'm thinking of on the 4th of July during this stream, making a bacon apple pie because it sounds, that's not what they were saying, but it sounds, I mean, like, I'm going to pie, apples, bacon, pie crust, lattice on top, lattice or whatever. That's how, and that's what it's going to be. And that's what I'm going to make with vanilla ice cream. I bet it's like 1,200 calories. I could probably get apple bacon, but I won't because I'm a strict regular baking kind of girl. I don't unless I have to. I don't get the maple bacon or even the smoked bacon. I go straight for just the regular bacon. It's making my mouth water. It's it's gonna taste. Oh, sugar! I hate these cats. Let's see if you still have sound.
And you understand that if I do find it with prejudice, which I'm strongly inclined to do, that means that you cannot bring this petition for a new trial again.
With these issues, you mean?
Yeah, well, that's technically true, although as you say, it is time barred, and so it would seem to me that any other petition for new trial would be time barred as well.
Unless we come across other prosecutional misconduct or whatever,
Well,
or other evidence.
if you find an exception to the time bar, perhaps.
Which would be other evidence.
Well, I suppose in theory, there could be an exception to the time bar, but put it aside from that, you understand that another petition for a new trial, certainly raising the same issues, would be barred essentially because you've waived the right to file them.
These particular issues, yes.
Okay.
But that
All
doesn't, I just want to make clear that, because I just want to make clear, if I come up with other evidence, if we just uncover other evidence, I will be able to file another petition for a new trial based on that evidence, that newly discovered evidence.
Yeah, well, I mean, we would have to decide that at the time based on what the evidence is, but the time, even if you found newly discovered evidence, unless it's of a certain type, the statute of limitations is 3 years from the time of your sentencing, which ran in 1998. You do understand that?
I understand that, but my understanding is that time bar doesn't toll if the state is aware of evidence or we discover evidence that should have been presented at trial that was exculpatory.
Right. Well, we may disagree a little on that. There are some exceptions to the statute of limitations, but ordinarily it's 3 years. Whether even if you discover new evidence on the 4th year, the statute would bar the petition after 3 years. That's the rule. There may be some exceptions. Do you understand that?
That's not my understanding.
Okay. All right. Well, Ms. Sulik, do you have some suggestions as to whether I should ask additional questions?
I believe that the petitioner right now is discussing the fraudulent concealment exception, which, of course, if the state fraudulently concealed certain evidence, could toll the statute of limitations. Additionally, there are exceptions for newly discovered DNA evidence or forensic science evidence. So there are exceptions, but again, it could be a very high burden on him if he wanted to come back in the future. And although he may believe that he could prove fraudulent concealment in the future, he should know that would be a decision for the court at that time.
Well, Mr. Smith, I think that's very well stated. Do you agree with that statement of the law?
I understand what she said.
Okay. All right. So the statute of limitations is 3 years. There are some exceptions. I do consider your withdrawal to be with prejudice in that you cannot bring the same claims again. I consider them to have been waived. So do you at least understand what I'm saying?
Well, I understand what you're saying.
Okay. All right. I think that should be sufficient, Ms. Sulik.
I agree, Judge. Thank you.
All right.
Your Honor, before we conclude.
Yes, sir.
There's one issue I'd like to.
Hold on, I have a question before you have an issue, okay? So what happens? It's not like he didn't say you can't do it again or else. He just said you can't do it again. So what happens when this guy does it again? He probably already did, even though this was from today, or I guess today is today. So it was from yesterday, but it's still today. This was just from a couple hours ago. And he's stuck in jail. And it takes weeks to get something out of jail, a piece of paper mailed to somebody. So he couldn't have done it again. But if he does do it again, what happens to him? And this is it. The case is dismissed. The judge just dismissed the case. So it's not going any further right now. He would have to start all over again.
To bring to the court's attention.
Okay.
Like I explained before, and Ms. Sulik set the stage for me to say what I said. I filed a motion to dismiss in this matter. It was returned to me by the clerk's office, who routinely review motions submitted to the court before they enter them to the system. They saw that my motion was deficient based on the lack of a signature. They sent it back to me. As I said, I corrected it. Drawing your attention now to your decision dated 5/16/25 in the my motion to have you disqualified to hear this matter. In your decision,
Judge, in your decision when I asked you to go away because I don't like you, so you should have been disqualified. In that decision, can I do that one again?
you stated specifically, the court conducted a hearing on this motion pursuant to practice book 1-22B. The motion is technically deficient in that it does not contain an affidavit.
That makes sense.
Or certification of good faith as required by the practice book. With respect to that matter, I'm quite sure that I correctly filed it. There was a certification attached to it stating that I sent a copy to Ms. Sulik. An affidavit was attached to it. I sent a copy to it of it to again Ms. Sulik. I have a copy of it. The DOC notary who notarized the affidavit that I attached to it has a record of it. The clerk's office, just like they did with the motion to dismiss, did not return that motion for lack of having a certification attached to it. So I don't understand. I don't understand what's going on.
Right. So
Judge, this is what you say to him. This is how you reply. You say, but dear sir, you don't understand. My dad was a drug user. So from a very young age, I started using drugs, and then it was my mom's fault that you didn't get your paperwork correctly done. And you as a judge, you're starting a new job on Monday. So you're going to try. This time you really mean it. This time as a judge, you're going to turn your life around. And that's what you say to him.
could look, I don't specifically, let me take a look at my file. This is kind of a moot issue at this point, but
And not to interrupt, but like I said, if there was a deficiency in that motion, the clerk's office, before it touched your desk, would have returned it to you.
all right, actually, I have a copy, and attached to it is an affidavit that is sworn to by you. Let's see.
I'm sure the certification is attached to that as well.
Yeah, the problem was not certification to opposing counsel. You always do that. The problem is that under the practice book, there has to be a statement of good faith. That's 1-23 in the practice book, and I didn't see that. So, That was a technical ground for denying your
Oh, he
motion.
didn't have a statement attached to it, guys.
But the real ground, that's 1-23. The real ground was that I'm not biased in any way. I decide cases on the merits, and I played the transcript of the hearing, and I didn't say what you thought I said. So that was the minute.
Guess what, guys? Speaking of the transcript of that hearing, I have it. And I showed it to the other mods, right? And we decided that we're going to try to reenact it. We're going to each record our own part and reenact this hearing for you guys on like a cartoon, like reenactment, not like in real life reenactment. Not all mods want their voices heard, so you won't hear all mods. And that's fine. You don't have to. But I don't even know how many parts I need yet for this. But we were talking about it today. We're pretty excited about it. And that'll be a pretty cool video. Yes. Yeah. One of us, me or CJ, one of us is going to have an accent.
Main reason I denied it. Okay.
All right, then. Yep.
Okay. Thank you, sir. Good luck to you, and we'll stand adjourned. Thank you, Ms. Sulik.
Thank you,
Court
Judge.
stands adjourned.
You're the real Sybil. Okay, now this next one, I have a preamble to it. I'm not going to read all this. Don't worry. Even though it's not a lot, I'm not going to read it. I am going to read it. I just lied to you all. I'm not going to read it all. I'm just going to highlight. Crystal is a woman. It's Crystal Joseph. All right. That took me a while. My brain didn't get there. She's suing the police department in Connecticut. Connecticut was juicy today. I missed the best case of all of them, though. I fell asleep and woke up 39 minutes too late. Some lady and her husband, she couldn't have kids. They took 10 of her eggs. They froze them. And she had triplets. So 3 of the eggs worked. She had triplets. She naturally had another child. Then she used the eggs and she had another child. She has 5 children now. And she wanted more children, but they had accidentally thrown out all of her eggs, the rest of them. So she's suing for a lot of money. Hi, Dan. Nice. I'm glad your new YouTube account is off and running. All right. So she's suing the police department. She's saying that they went into her house unlawfully, okay? And they contaminated all of her food. They took a bunch of her stuff. They did it without a warrant. They took money, jewelry, clothing, books from authors. This is her complaint. This is exactly how she typed it. Except I took out the address. Like she had the address and she had her phone number and everything. Yeah, she contaminated her food to cause harm or death to her. Putting different contaminants in food and hair products. Causing an investigation to be performed by CVS, but the health department as well. And they were retaliating and bullying her and intimidating her. And she reached out to IA. And she was threatened to be arrested when she reached out to IA. And then someone hit her vehicle and the police just let them walk away. So the failure to do their job. Blatant. Theft. Pro-Sears. Refusing to do their job. So she wants money, moving expenses, and money for mental anguish, restitution, and relation fee. Donald, I think you asked for it. You kept talking about eggs. If you don't like eggs, don't talk about eggs. I don't talk about owls. Okay. Kitty, talk about owls instead. Just talk about owls. Kit Kat. Why did you make me call her Kitty? Come on. Come on now. All right. I don't know what relation fees are. Don't know. I don't know. But we're about to see her in this hearing today. And what I think this hearing is, if I remember correctly, is she is bringing a case against the police department to dismiss a case. And they are bringing, for summary judgment. She wants summary judgment, and they want summary judgment. They both filed for summary judgment. So I do not know how this ends. I think I watched it, but I just don't remember it. And now I can't. All right, before we hop in to that, I just have like a 2-minute little a breather between this Connecticut case and that Connecticut case. Just let what I said about what's going on with the police department sink in while we watch Miss Davis. Miss Davis.
Yes, Your Honor. First, the people would be asking that the court adopt the finding of incompetency that was found in Denver District Court Case 24 CR 2216 for Miss Davis. That was found on May 19th, 2025.
Thank you. Are there restoration services being ordered for Donta Davis?
It appears that it appears that the court converted in custody to out of custody restoration on the 24th of this month, but I have brief further record if the court is inclined to adopt those findings.
Yes. Go ahead.
Your Honor, given the fact that the highest charge in this case is a Class 2 misdemeanor, the people would put on the record that under statute that there is a mandatory dismissal required. The people do not have any objection to a court dismissal of Miss Davis's case.
Thank you. Ms. Grindon, I take it you're joining in that request and not objecting to magistrate.
You are correct, Your Honor, and thank you, Ms. Best, for proactively noting that.
Ms. Davis, the court has heard arguments of counsel. In this case, I'm adopting the findings from the Denver court, and I'm sorry, I lost that case number. Would you read that into the record, please, Ms. Best?
I'm sorry, Your Honor, would the court repeat that?
The Denver, is it the Denver District Court 2023? Which case out of Denver?
2024 CR 2216.
Thank you. I'm adopting the findings.
I don't know why it stopped, but it doesn't matter. We saw what we needed to see here. Yeah, he's a little quick. He's a little quirky too. He is. She has a full beard.
I can imagine my matters are going to
Don't
be
worry, they're
quick, so
coming. They're
Judge
coming.
Singar will come on right after. So just stay posted. I would imagine my matters are going to be quick, so Judge Singar will come on right after. So just stay posted.
Of course, she has no camera. She's calling in. She's right here, guys.
We are on the record, Your Honor.
All right, thank you. So the first matter I'm going to call is Crystal Joseph versus the Stamford Police Department. Are the parties here on that matter?
Yes, Your Honor.
Crystal Joseph present, Your Honor.
Dana Lee for the defendant.
All right, thank you. Miss Joseph, do you have a camera or?
I am on audio.
Okay. All right, no problem.
See, now she lost her golden opportunity right there. If I was her and I was suing the police department for stealing my stuff, and the judge said, excuse me, Kathy, do you have a camera? I would have said, no, they stole it. They stole my phone when they came in here. They stole it, Judge. I don't have nothing. I got an old Nokia I found behind the sofa, which they also stole.
All right, Mr. Lee, this is your motion to strike. You can proceed if you like.
Thank you, Your Honor. This motion to strike was filed after two earlier requests to revise. So the case is almost a year old. The motion to strike is focused at all 5 counts of the complaint. All of the counts of the complaints of the amended revised complaint suffer from a lack of specific factual allegations, that they're conclusory in nature and unsupported by any factual allegations. All of the counts suffer from that. As the court can look at the current.
I understand that is lawyer talk, but what he's really saying is everything she said was bullshit, Judge.
Complaint, basically each count is one paragraph filled with really 1 or 2 sentences with conclusory allegations. And this is after 2 requests to revise. In addition, the counts the first count, the second count, and the third count, they allege and rest entirely on criminal statutes, which have not, the legislature has not created a private right of action for those. That's a basis for the motion to strike. The third, count 5 is an allegation of a general failure of the police officer to investigate or do their duty, and that's discretionary and barred by governmental immunity. So, in sum, Your Honor, the amended revised complaint is legally deficient in form and
I know it sucks, but it's pretty cool. I hope it goes well today.
substance. And quite frankly, we're almost a year into this, and I have absolutely no idea how to investigate this complaint, which is the primary reason why I'm filing this motion to strike. There have been multiple chances where I have, in the request to revise, informed Ms. Joseph what I need in order to investigate and what she needs to do in order to comply with our practice book so that I can properly defend the case. And it hasn't happened. So these are I respectfully request the court grant the motion to strike for the reasons set forth in the motion. Thank you.
All right, thank you. Ms. Joseph.
I'm here, Yana.
Yep, it's your turn if you want to tell me anything.
She does.
I revised my complaint on several instances. What Mr. Dana is asking for, I do not know. Basically, the Stanford police was entering my unit unauthorized while I was not home. They were taking my belongings. I had an ex-boyfriend of mine that had gotten keys to my apartment.
We have seen Jeffrey Lynch before, by the way.
By theft, of course. And he was doing this. He began to take things that didn't belong to him, clothing, all
Ms.
kinds
Joseph,
of things.
Ms. Joseph, I read your complaint and I know what your allegations are in your complaint, but what is your response to Attorney Lee's motion to strike the counsel?
I answered his what he requested to the best of my ability. Basically, I have the proofs and stuff like that as far as I needed to have State Farm refund me over $10,000 in theft, you know? And when I would go to the precinct, they would laugh, they would dismiss me. A lot of times they would not take my report, you know? And yeah, I'm a victim here, and I want this case to move forward. So if Mr. Dana is asking for something else, I have spoken to him. If he's asking for something else that I didn't provide, I have no idea what it is. I to the best of my ability, I answered his questions, you know.
Okay. Do you have anything else you want to say?
Not at this time, Your Honor.
All right, thank you very much. Attorney Lee, do you have anything further?
Nothing further, Your Honor. Thank you very much.
All right, thank you both. I'll reserve decision and have a great day.
Thank you.
So we're going to keep an eye on that one. Don't worry. That is one that we are going to keep a close eye on to see if she wins her lawsuit against the police department. All right. I didn't set up OJ. I'm going to set up OJ right now before this video is over. Thank you so much for coming out today. Thank you, Kelly. Thank you, Michael. Listen, I really appreciate it. I really do. I'll see you, a few of you in OJ. And I'll put up that stream later so everybody knows exactly what time it is. Have a great day, guys. See ya.
Electric light, late night when the world sleeps. She's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Right, even when my world turns gray, with a giggle she lights the way. Her eyes hear a sky so blue, in her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted sharp, in a way there's no alarm. Streaming tales late into the night, her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted sharp, in a way there's no